Hello everyone, our today's video is about the Republic Act 10592, or otherwise known as the GCTA Law or Good Conduct Time Allowances Act. By the way, this is Muhammad Saifur Rahman Benito, and let us get started. So, Republic Act 10592, an act amending Articles 29, 94, 97, 98, and 99 of the Revised Penal Code, also known as Good Conduct Time Allowances Act, GCTA Law, signed in 2013 under then President Benigno Aquino III Noynoy. So this allows deduction from sentences of persons deprived of liberty, PDLs, on the basis of good behavior. So this has been the center of debate because most of those who were released or about to be released were because of their good conduct were heinous crime convicts. So we have here as a sample the former mayor of Calauan, Laguna, who was accused and convicted of rape and murder. So it is a heinous crime. So Section 1, Article 29 of the Revised Penal Code as amended, which provides that period of preventive imprisonment deducted from term of imprisonment. So take note that in this section, it has stated that recidivists, habitual delinquents, escapees, and persons charged with heinous crimes are excluded from the coverage of this act. So therefore, Mayor Sanchez and all others like him who were convicted of heinous crime are not covered. So the following sections will be discussed by our beloved Ms. Bunabi Edelor.
RA number 10592, under Section 2, Article 94 of the Revised Penal Code is amended. So Article 94 is the partial extinction of criminal liability. Criminal liability is extinguished partially, 1. By conditional pardon, which refers to the exemption of an individual within certain limits or conditions from the punishment which the law inflicts for the offense he had committed, resulting in the partial extinction of criminal liability. 2. By commutation of the sentence, which refers to the reduction of the duration of a prison sentence of a prisoner. 3. For good conduct allowances which the culprit may earn while he is undergoing preventive imprisonment or serving his sentence. Allowances for good conduct are deductions from the term of the sentence for good behavior and for study, teaching, and mentoring. So good behavior is defined as the conspicuous and satisfactory behavior of a detention or convicted prisoner, consisting of active involvement in rehabilitation programs, productive participation in authorized work activities, or accomplishment of exemplary deeds coupled with faithful obedience to all prison or jail rules and regulations. So under Section 3, Article 97 of the Revised Penal Code is amended. So Article 97 is the allowance for good conduct. The good conduct of any offender qualified for credit for preventive imprisonment pursuant to Article 29 of this code or of any convicted prisoner in any penal institution, rehabilitation or detention center, or any other local jail shall entitle him to the following deduction from the period of his sentence. This table shows the number of days as provided in the Revised Penal Code and under the RA number 10592. So note that the number of days herein, reflected herein, are deductions per month of good behavior. So during the first 2 years of imprisonment, from 5 days, it will now be 10 days deduction. During 3rd to 5th year of imprisonment, from 8 days, it will now be 23 days deduction. During the following years until the 10th year of imprisonment, from 10 days, it will now be 25 days deduction. During 11th and successive years of imprisonment, from 15 days, it will now be 30 days deduction. And another provision added under RA number 10592, which gives 15 days deduction per month of study, teaching, or mentoring service time rendered, which can be given at any time during imprisonment. So an appeal by the accused shall not deprive him of entitlement to the above allowances for good conduct. So the following sections will now be discussed by Ms. Chini Pavida.
Thank you, Ms. Bonavi. Now let's proceed to Section 4 of Republic Act 10592, which is Article 98 of the Revised Penal Code. Article 98 of the same Act is hereby further amended to read as follows. Special time allowance for loyalty. A deduction of 1/5 of the period of his sentence shall be granted to any prisoner who, having evaded his preventive imprisonment or the service of his sentence under the circumstances mentioned in Article 158 of this code, gives himself up to the authorities within 48 hours following the issuance of a proclamation announcing the passing away of the calamity or catastrophe referred to in the said article. A deduction of 2/5 of the period of his sentence shall be granted in case said prisoner chose to stay in the place of his confinement, notwithstanding the existence of a calamity or catastrophe enumerated in Article 158 of this code. This article shall apply to any prisoner whether undergoing preventive imprisonment or serving sentence. So, Section 4. During a state of calamity or an emergency, a PD has a choice to leave or to stay. If, for example, during a state of calamity, a PDL evacuates prison and then within 48 hours, he returned and surrendered himself, he will be given 1/5 deduction of the period of his sentence. Well, those PDLs who chose to stay during a state of calamity, they will be given 2/5 deduction of the period of his sentence. Now, let's proceed to Section 5 of Republic Act 10592. Article 99. Who grants time allowances? Whenever lawfully justified, the Director of the Bureau of Corrections, the Chief of the Bureau of Jail Management and Technology, or the Warden of a provincial, district, municipal, or city jail shall grant allowances for good conduct. Such allowances, once granted, shall not be revoked.
What's shown here in the presentation are the remaining provisions of RA 1059-2. What's relevant here is the IRR that was created by virtue of Section 7 of this law. This IRR was actually revised because of the good conduct time allowance controversy that happened involving multiple employees of the Bureau of Corrections, or BUCOR. So this controversy started with multiple news reports released stating that former Calauan Mayor Antonio Sanchez was convicted of 7 counts of rape with homicide, was about to be released following the retroactive application of the GCTA law on his case. So following that, Senator Lacson also revealed that 4 out of the 7 convicted of the Chiang sisters murder case were convicted for murder were actually already released under GCTA law as well. So this sparked multiple protests and a Senate probe. Following that, President Duterte decided to fire and Director General of BUCOR, Nicanor Faeldon. After that, President Duterte instituted a call for surrender for the 1,914 convicts who were charged with heinous crimes that were released under the GCTA law. He said that they are given 15 days ultimatum to surrender themselves to the authorities. Otherwise, they're going to be considered fugitives from the law and they're going to be apprehended accordingly. So the next slide is about the revised IRR and the important revisions to note. First important revision was it enumerated who among the convicts are disqualified to avail of the GCTA under the 1059-2. So the second distinction were the distinction between the persons charged with heinous crimes before and after the passage of the law. So if you're charged before the passage, then you're still entitled from the GCTA under RPC, which is about 5 to 15 days per month. If you're convicted after the passing of the law, then you are not entitled to any GCTA at all. So the third is that it enumerated which is included in heinous crimes. Fourth is that the DOJ participates in deliberation of the release. And fifth is that the convicts are to be published if they're to be released under the law.